Mr. Robert Baker, who spoke yesterday on the problems with B.F. Skinner. Today, and many of you had some questions about the problems with children. Well, now, Mr. Baker's topic will be called Kid Lib. Robert Baker.
Thank you. Well, good afternoon, ladies and gentlemen. It's good to see you all back again. It's very boosting to see so many people hanging on my every word. Much the way at the conclusion of the murder mystery, the constable informs the chief suspect that anything he says will be taken down and used in evidence against him. Yesterday, the mere mention of today's topic raised so many questions, so many interesting questions that were so hard to answer that I've decided to talk about the foreign policy of New Guinea instead. No, I really wouldn't do that. It's just that all this audience is sitting back there with the respectful look that a hungry lion gives to a gazelle. Now, as was mentioned by an earlier speaker, we're running a bit late, so I'm not going to talk very long, and we're going to leave as much time as we can for you to ask the questions that may be on your mind. I'm going to speak entirely from my notes rather than from a prepared text. Now, my present purpose is to... Am I dead? Okay, fine. My present purpose is to focus attention on a relatively neglected area of libertarian thought. I think that we should begin at home as libertarians in this question of resurrection of rights. And I'm going to speak about the rights of persons who have been neglected. Now, I claim no special competence in the area of problems related to children, except perhaps some competence in the area of the law, and there some of my professors have been known to dispute me, as a matter of fact. I'm looking primarily for approaches, that is, the proper way of thinking about questions relating to children, rather than pretending to you that I have a great many definitive answers. In addition, I'm concerned with practical problems. Since I spoke yesterday, many people have asked me questions like, well, how about two kids being in a spaceship? The answer is I don't know. I never saw a kid in a spaceship. It is necessary for our theories to help us guide our actions, to live. And to give you an idea of the sort of problem that I am concerned with, I want to tell you one that occurred, not a problem exactly, but an anecdote that occurred in my own life. Many years ago, I had a child, a little girl. And at the age of about 3, she had been brought up with all the proper information on property rights and the rights of the individual. Now, smart little bitch. And I was sitting on the couch with her one evening and studying a scientific text, a chemistry text. It was a modern text and had a beautiful picture, a plate in it, which depicted a molecular structure. And she sitting next to me saw it, reached over, and she attempted to pull it out of the book. I pushed her hand away and I said, Carolyn, honey, hasn't Daddy told you that you must love the book? She says, okay. She gets down off the couch. She goes into her room. She comes back a few minutes later with one of her books, and sits up on the couch next to me and begins to read. A moment later, I hear the sound of tearing. I look, and sure enough, there she is, pulling a picture of a giraffe out of her book. And I said, honey, I just told you a minute ago, you must love the book. She looks up at me, says, my book. So I let the fool pull her book apart. Now these are the problems that I'm going to be concerned with. First of all, is it a real problem? I say yes, it is. There is discrimination against children. First, I want to point to some of the areas of legal discrimination. The Supreme Court of the United States once said that a state may permissibly determine that a child is not possessed of that full capacity for individual choice, which is the presupposition of First Amendment speech guarantees. Closing the quote. Just to give you an idea. In no state of the Union, to my knowledge, is a child who is accused of crime entitled to bail. A child for the act of running away from his home may, without a trial in our sense, be sent to a reformatory for a longer period of time than a criminal who assaults you on the street. A parent may consent to the search of a child's room without consulting the child, and any evidence seized there can be used in what is called a juvenile proceeding against the child. Not only are there legal discriminations against children, but there are also social ones to which almost all of us fall prey. The mere title of this speech, which I did not design as a matter of fact, indicates one of them that we never think of. Kid live. What's a kid? If nowadays I were to walk up to a brown man and address him as boy, I would be courting a suck in the mouth. And as far as women are concerned, if you've come such a long way, baby, then how come you're still being called baby? Yet we think nothing of walking up to a young human being and calling him kid, with all the subliminal contempt that is implicit in that word. It gets more serious than merely snubs. The media is constantly telling us of the battered child problem. Go to the intake room of any hospital in a large city and see how these children are brought in. The problem is real. Just a bit on the early legal attitudes toward children. Under the law of many societies, including that of Sparta, including that of Rome, the father of a family had the absolute power of life and death over his child. And it meant that a Roman father could, if he chose, simply kill his child with no approbation except perhaps moral from his neighbors. Our English common law did not adopt quite that bad a view, but the early English society was a society of status rather than a society of rights. It was early said by Blackstone, for example, that parents, particularly the father, did have certain obligations toward their children. But these obligations were called imperfect obligations. You could not enforce them at law. Fat lot of good this did children. Nevertheless, although a child was owed no obligations that could be enforced, he certainly had responsibilities, particularly criminal ones. And there are cases of children as young as 8 years old being hanged for crime in the 17th century. Fortunately, this changed considerably. In part, it changed on the basis of a legal procedural device known as the presumption. It was presumed under the common law that no child below the age of 7 had the mental capacity required to form the evil intent required for a crime. And between the age of 7 and 14, he was assumed not to have such mental capacity, but his accuser could prove differently. Above 14, fully responsible for his acts, but he had no claim upon his parents. As time passed, the state developed the idea of what they call parens patriae, the state as forming a surrogate parent. But unfortunately, The only thing the state was interested in was raising what it called better citizens. Now I say that with this kind of historical background, libertarians, who are considered the rights fanatics of the world, have a special intellectual obligation, if they're going to preach at all, to define and to delimit what the rights of children are. Children are human beings. They are not some kind of alien creatures from 20,000 fathoms. They do have a tendency to be small, and sometimes they are helpless, and this is why we pick on them, but they are people. Now, I'm aware it's possible to deny that children are human beings, as it was once possible to deny that Negroes are human beings. Once, theologians debated on whether or not women had souls, but I don't accept this as a serious issue of debate. They are people. But if children are people, then I say they are possessed of rights. Now, you can formulate this issue of rights in many ways. We all know a very famous one, which I quote now. Rights are conditions of existence required by man's nature for his survival, close quote. I won't give you the source of that. It is possible to make alternative formulations of the source of rights, at least the nature of rights. But I say that there's no grounds for distinction, no matter what your formulation is, and there's certainly no grounds for distinction based upon age. Children have rights, and I say they have all the rights of any other human being, so long as we concede that they are human beings. The duties of parents. In general, we own that which we create. There is one and only one exception. We can create a human being, but we cannot own a human being. Under our law, a parent owes to his child, whom he has created of his own free will, food, clothing, shelter, medical care, and education. But parents are not slaves to their children, any more than children were once slaves to their parents. What is the reciprocal obligation of the child? At one time it was contended that all the wages that a child might earn belonged properly to his father. I don't think that an argument can be made to the extent that everything a child might gain is his parents. But I think we can say that if a child has rights, and if his parents also have rights, then it is up to them to form an agreement whereby their mutual obligations are outlined. We'll come to the question of how you form an agreement with a 3-month-old baby in just a minute. Now, the parents create this helpless thing, but it's a human being. In so doing, I say that the only reasonable approach is to contend that they have a minimum obligation to get this helpless human being past his period of helplessness. They must not, in doing this, violate any rights. I wish to contrast 2 examples. Pardon me. One of the most common medical factors with a child is the performing after a few days a circumcision upon the male. At the price you were charged, they could have provided water. I claim that this is a violation of rights, and I will tell you why I think it's a violation of rights. I also request someone to get me some water. And I'm going to contrast it with the case of a tonsillectomy. Some people have claimed such devotion in the case of a wife is just beyond belief. Some people have claimed there are good medical reasons for the operation known as circumcision. There may be. It's a medical issue, not one I'm competent to take into consideration. However, it is certainly not an emergency. To circumcise a child is to perform an assault upon him. He is in no position to give consent. But, either a doctor or an anti-Semite, but I nevertheless will justify the performing, thank you dear. I will nevertheless justify the performing of a tonsillectomy upon a child. Because this comes about only when a child is in an emergency situation and is incapable of deciding whether or not he wants a tonsillectomy. Now, it can be contended, of course, that we might have an 18-year-old child. And who is to say that he is incapable? We'll come to that. The important thing is that we must do nothing to a child except emergency provisions if he is incapable of giving his consent. I've used this word child a great many times. Well, what is a child? The law doesn't even use this word. It uses the word infant, but I'm avoiding that because with infants we always think of diapers and very young children. A child is nothing more than an immature specimen of humanity, not yet capable of exercising his powers. But notice I say powers. Nothing about his rights. His rights are there from the moment he becomes a human being. Let me give you some comparative examples. There are lame people who have lost the use of their legs. No one would deny that they have a right to walk in the public park. A mute who cannot speak nevertheless retains his right of free speech. And I think we'd all agree that, say, a 95-year-old man does have a right to take a bride. I thought it was pretty good when I thought it up, actually. But the subject is serious here. I want to consider the vital importance of the individual case. When we discuss the rights of any special delineated class of human beings, like women, like Negroes, like children, we always say something like, the child wants thus and such. The woman should be made equal to the man. Where are these creatures? I can't see them. I have never met the woman in my life. Every human being is unique. Every child is unique. It is not for me to say that there are no 7-year-olds who are incapable of coming up here and giving a speech. No 7-year-olds who are capable of voting. At the same time, there are 21-year-olds who, because of their individual lack of capacity, should probably have committees appointed for them. They usually go into politics. Now, an approach I suggest in the case of deciding whether or not a particular child is capable of exercising a power in furtherance of his undoubted rights is that the old English law used in the case of crime, that of the presumption. You see, the problem we have here is mainly a procedural one. Not does a human being have rights, but how do we know when he's capable of exercising them? I say that when a case arises and we want to know if a particular child is capable of exercising a right, first, the burden of proof is upon him who denies it. Because what is the alternative? You, sir, are not capable of exercising a right. May I put you to the test of proving that you are? Can you respond that your age makes it obvious? Well, if the age of 21 makes it obvious, why not the age of 20 or 19 And I'll keep going back to the cradle. We can take an easy case that was presented to me by a questioner not long ago. An infant of the age of 2.5 or 3 is crawling toward the door, and outside lies the superhighway. Do we have the right to stop him? The question was meant seriously. Obviously we have the right to stop him. Why? Does he not possess the right to walk where he pleases? Yeah, sure he does. Does he possess the power to exercise that right at that age? We don't know. He can't tell us. We will presume that he does not wish to crawl out into the traffic. But there are more serious cases. How about the child of 13 who also wants to walk? He wants to walk away permanently. He's got a drunken father and a whorish mother, and he wants to get out. He wants to fire his parents. How about him? I think that one is also easy enough to take care of with a presumption also. The presumption is that he who shows the obvious exercise of his rights is able to, and the burden of proof is upon him who denies it. There is an old custom, an old procedure in the law, known as the appointment of a guardian ad litem for children. Since we have an adversary system of justice under the Anglo-Saxon system of law, if two parents, for example, get in a quarrel over a child, say the custody of a child, who is to defend the rights of the child? Well, the courts don't put it that way. They're more interested in the welfare of the child. But the court appoints an outside person, usually an attorney, who will represent that child and protect him. I say that in any reasonable judicial system, whenever a child is exercising a right and someone contends that he is not capable of doing so properly, that the wise tribunal will appoint for that child a guardian ad litem, not responsible to the court, not responsible to the adversaries, but responsible to the child to support that child's rights. Things are getting better. It's already settled law in this country that a parent may not deny to his child a blood transfusion, for example, just because the parent happens to think it's a bad idea or is against the parent's religion. Yet at the same time, our courts have repeatedly upheld the right of a human being who is an adult, and unfortunately the court defines an adult as 21 years of age, not to take any blood transfusion, to let himself die if he wants to. The problem is that the courts, operating in a collectivist society, like to think of the child, and the child is anybody under 21 years old. In a wise system of jurisprudence, if a child of any age said, "I do not want that blood transfusion," then the burden falls upon him who says the child is not responsible. Let him prove it. He is exercising a right. I'm going to bare my breast here of slings and arrows in just a moment. I want to sum up the position that I have taken for an approach to the solution of these problems. Children have rights, the same rights as adults. They may, in individual cases, lack the power to exercise their rights. The presumption is always in favor of rights, and the burden of proof is on him who wants to interfere. And as soon as I get this frog out, we'll go into a lot of mean questions.